told you. That I didn't ask or inquire about anything that was said. I just want to know who it was. Okay. Because he's got too much detail of this particular alleged conversation for the court to be concerned about it. So.
And Judge, since it is a criminal contempt, he is entitled to due process. He's entitled to a hearing, entitled to an actual show cause, entitled to the allegations actually written, entitled to a witness list. We're entitled to present our own witness list. And
well, no,
notice of that.
criminal contempt is different. It is on the spot. So he's gotten the due process he's going to get. That's on the spot. I told him. Plus, he's had all day to tell me who it is that is it. So a little different, Ms. Merchant. I'm going to disagree with you, but
well, and
okay.
Judge, just for the record, it's that's direct. So what you're holding him in is in direct criminal contempt.
Yes.
The issue with the direct criminal contempt is whether or not to actually hold a hearing now, whether or not it needs to be held immediately. And the problem is, if you hold him in direct criminal contempt, as you're saying that you did, you are a witness to that proceeding. And so it has to be referred to another judge. It doesn't require recusal. You actually have to sua sponte send it to another judge because you are a witness to the proceeding.
Show me the case law that says that, Ms.
Yes,
Merchant.
it is Henry McClarty. It's 152 Georgia App 399. And it says that is one of the cases. Also, two other cases, Henry Adams, 215 Georgia App 372.
Well, 1 second. Give me the name of the first case again.
Judge is like, how do I use Google again? Ashleigh Merchant is so sharp. It is unbelievable. This judge has no idea who he's up against.
Henry what?
Do you want just the number, Judge?
Yeah, I would. Thank you.
215.
215.
Georgia App.
Georgia App.
372.
Okay.
Also 215. Georgia App. 349.
Okay.
That's Adams and Hasty.
All right. Let me take a look at those.
Yeah, you got to do your homework, Judge. Hey, happy Friday, guys. Hope you guys are doing well. If you guys have been following the channel for any length of time, you guys know I'm a big fan of holding power to account, right? And this is exactly what lawyer Ashleigh Merchant is doing right here. Now, if you guys remember, Ashleigh Merchant, she was the one to bring up the impropriety case against DA Fani Willis in the Trump Georgia case. Now, at this point, she's bringing up yet another injustice in a Georgia courtroom, again connected to Fulton County DA Fani Willis. Now, Ashleigh Merchant, she actually came to the defense of another attorney by the name of Brian Steele, who is representing a musician by the name of Young Thug, Jeffrey Lamar Williams, in the Young Slime Life trial in Fulton County, also known as YSL. Now, Brian Steele, he's the attorney on that case for the defense, and basically he was arrested and held in contempt of court after he confronted the judge that you guys are looking at right now, Ural Glanville, about a conversation reportedly held between the judge, the prosecutors, and the star witness. Now, going even further, Glanville asked Fulton County prosecutors, people under Fani Willis, witness Lil Woody, the real name is Kenneth Copeland, and witness's attorney Kayla Bumpus, to appear at a June 25th hearing and show cause for why they should not be held in contempt for disclosing information about the ex parte conversation to members of the defense counsel. Get this, guys. Glanville said if any of the Fulton County prosecutors who were present at the meeting, Copeland or Bogus, or if they don't show just cause, he would then direct Fulton County Sheriff Office to take them into custody as well. This judge is completely out of control. Translation, Glanville is trying to close ranks to stop possibly damaging information about him and the Fulton County DAs from getting out, from the DA's office from getting out. And like I said, guys, attorney Ashleigh Merchant, she's not letting it slide. Merchant told Glanville that he had a duty to inform the defense counsels that they were ex parte communications and they were being made in the main crux of Steele's argument, which was that Brian Steele, the defense attorney, should not have had to learn about it from wherever he learned about it. All right. Now, Ashleigh Merchant, I'm about to share this video with you guys. Ashleigh Merchant is also helping the Georgia State Senate go after Fulton County DA Fani Willis. But take a listen to this here.
Brian Steele into a hero of sorts among defense attorneys. Joining me is Ashleigh Merchant. She is Brian Steele's lawyer. She's also the president of the Georgia Association of Criminal Defense Lawyers. So Ashleigh, talk to me a little bit about how you end up at the Fulton County Courthouse last night at 7:30 at night, representing Brian Steele in this issue, this contempt matter.
Definitely not how I imagined my day beginning or ending.
Right.
I was in a meeting and my paralegal came in and said, your phone is lighting up and Brian's in custody. And I said, oh my God, call me on my phone. I'm getting in the car. I'm driving down there. And, you know, I've served for many years as GACTL, as our association's contempt attorney, where we have attorneys that we dispatch that are ever held in contempt. We call it Strike Force. So I'm a member of that. So I'm one of the lawyers that regularly would represent.
So for those of you guys who are wondering, where did Ashleigh Merchant come in from? Like, how does she get involved in this case? Well, basically, once the defense attorney that's up against DA Fani Willis's office was held in contempt, basically he's being arrested, the word got out to Ashleigh Merchant, and she represents other attorneys who end up basically getting held in contempt and ultimately arrested.
But when I heard Brian was in custody, I had to go myself. And luckily, he's very loved in our community. And so many members of our team went down there and were there. And so we had a very strong showing of force, but it was definitely something I did not expect to happen.
So Ashleigh Merchant, she's also helping the Georgia State Senate go after Fulton County DA Fani Willis. A Georgia State Senate committee investigating allegations of wrongdoing by the Fulton County DA heard more than 3 hours of testimony from defense attorney Ashleigh Merchant that largely went unchallenged by the mostly Republican committee. Now, this particular committee of 6 Republicans and 3 Democrats was initiated to investigate whether or not Fani Willis showed a potential conflict of interest or misused public funds in her relationship with special prosecutor Nathan Wade, who she hired back in 2021 before they claim their romantic relationship began. So is this the beginning of a full-on crackdown on Fulton County justice system? Like what is really going on here, right? But first, here's attorney Ashleigh Merchant talking about the Fani Willis case against Donald Trump and her probable link to the White House. Take a listen.
I think there's definitely a link to the White House. You know, we have also done open records for all of Miss Willis's reimbursement, her travel schedule, things like that, and they've denied that. And those are things that we should be able to get through the Open Records Act. So we actually had to file a lawsuit under the Open Records Act because they're refusing to give us all those. And those would show if she was reimbursed to travel to the White House, dinners, hotel, flights, things like that. So I think there's something that they're trying to keep away out of our view.
You have a chance.
Yeah, they're definitely trying to hide something here, guys. I mean, like, there is definitely something up. Otherwise, like, why would they be blocking these lawful requests for information on where Willis has been going, right? Now, with all this happening, maybe it's the whole Fulton County itself that needs to be investigated, or at least, you know, their justice system, you know, maybe the whole justice system for all I know. But yeah, so here's a scoop on the whole YSL trial, okay? So apparently, Fulton County District Attorney Fani Willis's office and the judge had this private chat and with a witness and did not let the defense attorneys know about it. You see, in 2022, musician Young Thug and 27 others, they got caught up in this big RICO case tied to the street gang called Young Slime Life. Now, this trial has been quite the spectacle, to be honest with you guys, especially lately with its fair share of drama, including some heated exchanges in the courtroom. I mean, it even made headlines for a number of different controversial moments, including shouting matches with judges and prosecutors. It's been a real circus here. So take a listen to this one here.
This trial, Ms. Hilton supposedly said actually all of the defendants and then all 26 people are disposed of. If that's true, what this is coercion, witness intimidation, ex parte communications that we have a constitutional right to be present for. So I understand that you're upset towards me, but I don't know what I did. Mr. Steele, I still want to know, how did you come upon this information? Who told you?
What I want to know is why wasn't I there? Why,
Sir, I'm going to hold you in contempt if you don't tell me who tell me who this
I
information
don't
was
want to
come
be
from.
held in contempt.
Well,
I'm not
then,
answering that question. That's attorney-client privilege information. I am not answering.
attorney-client privilege. Unless you were in my chambers, that's the only way you can figure out.
I am telling
I tell you
you-
what, I'm going to give you 5 minutes. If you don't tell me
don't
who
have
you,
to. I'm
if
gonna
you don't tell me
continue.
who it is, I'm going to put you.
But let me-
I'm going to put you in contempt
I
because
understand.
that is not attorney-client privilege.
Attorney work product privilege. I am not.
How did you get that information
don't
supposedly
answer
from
that
my
question.
chambers? Did somebody tell you?
I'm not. You should have told me.
Ooh, you got 5 minutes.
Well, I don't need it. I want to continue.
you got 5 minutes?
This is what I was told. Mr. Copeland,
recess.
Mr.
We're
Copeland made
recess.
statements that he admitted to killing Donovan Thomas and was. Don't take.
Yeah, guys. And so now Young Thug's attorney, Brian Steele, essentially kind of stirred up, a lot of mess here. And this made the judge really upset because the prosecutor and the judge supposedly told the witness, Lil Woody, whose real name is Kenneth Copeland, that he would be held in jail for the remainder of the trial and that those conditions could be true for all 28 defendants in the case. Now, basically, Steele, he's arguing that his secret meeting violated standard legal procedures, that a meeting with a witness without the defense attorney present violated procedural rules. Many other lawyers are supporting the same argument. Now, as Steele put it, you're not supposed to have communications with a witness who's been sworn in. So he's really frustrated that he's calling. He's frustrated to a point where the attorney being arrested right now under contempt is claiming, basically he's calling for mistrial, claiming that what has happened is just straight up outright coercion. It's witness intimidation. And he even told the judge that they definitely should have been included in any conversation with the witness. So he basically called the whole thing ex parte communications, that they have a constitutional right to be present for. So what do you guys think about this? Like, isn't this just like absolutely wild at this point? Now, by the way, if you guys haven't already, I know we're live. We got a bunch of folks in the live already. What's going on? Guadalupe Rubino, Papa V, we got Keenan Ripon. If you guys haven't already, take a second, hit the like button for the video. It's totally free. Subscribe to the channel. We got a lot more powerful information to share with you guys, updates. I know not everyone has been keeping up with this, with the trial. So for those of you guys who already know, some of the background details, great, but not everyone knows that necessarily. So I just try to keep everybody on the up and up because some people are just finding out about, some of these trials and the corruption that's taking place. So sometimes I have to give a little bit of a backstory just to catch people up because not everyone's at the same point in the timeline, if that makes sense. Again, subscribe. Totally appreciate you guys hitting the join button. So anyway, like I was saying earlier, Brian Steele, defense attorney, he basically revealed that the judge and the DA's office met with Copeland and Copeland's counsel early in the day, and that none of the defense team, to his knowledge, was even aware that this conversation went on. Now, of course, Judge Glanville, he blew up and said that this meeting was ex parte, which allows the court to meet with one party without requiring all parties to be present, meaning it was just between them without everybody else. Now, Glanville, he went on to press Steele on how he got wind of this meeting. Now, Steele's response, he's like, hey, I'm not going to answer your question. That did not help matters at all. In fact, it riled up the judge even more. He sternly warned Brian Steele that, look, if he didn't explain where this information came from, he's going to have a problem. Now, Glanville said that, it's disturbing how Steele was somehow gotten this information in regards to the court's private ex parte conversation with a party. Despite the tension, though, Steele, he didn't budge. He was not going to just give in to the judge's threats. So he expressed his frustration, basically saying, hey, I understand that Glanville is upset toward him, but he doesn't know what he did wrong. at the end of the day. Because the attorney, let me know, guys, did the attorney do anything wrong? I don't see that the attorney did anything wrong. In fact, it looks like there's just nothing but corruption going on in the courtroom, and the judge appears to be a part of it. And again, he just doubled down and said, hey, I just want to know why he wasn't there. So Glanville, the judge, raised the stakes again, threatening to hold Steele in contempt if he didn't reveal how he found out, what was said in the chambers, or in his chambers, I should say. So the judge gave him a quick 5-minute deadline to reconsider before he left the courtroom, all pissed off, right? Now, as Glanville walked out, Steele also revealed that Copeland allegedly admitted during that meeting with the judge and the prosecutors that he killed Donovan Thomas Jr. Now, Thomas, who prosecutors say was a member of a rival gang, was shot and killed at a barbershop in 2015. Prosecutors argue that this death sparked an escalation in violence between the two gangs. Now, Judge Glanville, he pressed Steele again for his source after the break. Now, this break was more than 5 minutes. He was gone for like an hour. Even asking the judge to declare a mistrial because his client, Young Thug, he did not want to continue the trial without him being present. After Steele refused to tell him and signaled that he would move for a mistrial, Glanville accused Steele of eavesdropping and gave the attorney until 5 p.m. to think about it, saying that he would be ultimately held in custody until then. So Steele still refused to reveal his informant, and he was ultimately escorted out of the courtroom, but not before telling everybody in the courtroom how Glanville was removing him against his will and taking away his client's right to counsel. So, I mean, it's wild, right, guys? But so, this kind of thing, it really it makes people have zero, I'm talking zero trust in the legal system. I mean, for a judge to be able to just throw somebody in jail, some would just call that a whole lot of BS. You know what I'm saying? But despite the ongoing drama and, still in contempt, Brian Steele, he was allowed back later at the DA's request, but given a firm deadline to reveal his informant or face arrest again. Now, support for Brian Steele has been overwhelming, guys. I mean, outside the courtroom, there was a notable presence of lawyers rallying behind Steele. Now, according to reports, a sea of attorneys gathered outside the courtroom in support of Steele, including you had Ashleigh Merchant, president of the Georgia Association of Criminal Defense Lawyers. You had Steele's law partner and wife, Colette Resnick Steele. She filed a notice to appeal and a motion for bond. Now, by June 12th, 2 days ago, the Georgia Supreme Court had stepped in, granting Steele a supersedes bond. Basically, what it means is he won't face jail time while they appeal his contempt charge. And so basically the court has also agreed to hear the appeal, recognizing the gravity of the underlying criminal case. So at this point, they're saying that not only should the judge be disbarred, but the prosecuting attorneys who met with the judge should also be fired and also disbarred and also thrown in jail. What do y'all think? I mean, this could be considered some serious overreach by a lot of people, guys. I mean, the team from Fulton County District Attorney Fani Willis's office also got a serious heads up from the judge handling this YSL trial. You got Judge Glanville, who's determined to find the source of a recent leak, has called for a contempt hearing for everyone who was a part of this closed-door meeting that Steele found out about. I mean, after this whole shouting match with Steele, Judge Glanville, he ordered the Fulton County prosecutors, witness Lil Woody, real name Kenneth Copeland, and his lawyer, Kayla Bumpus, to show up on June 25th and show cause for why they should not be held in contempt for essentially disclosing information from the ex parte conversation to members of the defense counsel. So basically, the judge is now asking them to explain why they shouldn't be held in contempt for leaking details from that meeting to the defense lawyers. Now, Judge Glanville, he warned that if the prosecutors, Copeland or Bumpus, can't provide a good reason for their actions, he would direct the Fulton County Sheriff's Office to take them into custody as well. Basically, this judge is out of control. He's trying to arrest everybody at this point. Now, it just kind of goes to show how bad this whole thing has gotten over in Fulton County. In fact, the Atlanta legal community has already rallied behind Brian Steele. Dozens of criminal defense attorneys arrived at the courthouse to show their support. Ashleigh Merchant, who chairs the state's criminal defense attorney association, she defended Steele before Glanville. And that's what we saw earlier in this video here.
It's a 2005 case, and it defines direct contempt and explains that it must actually interfere with the proceedings to be direct. There's also a couple other cases on that.
See, but you all are covering under, let me see.
I'm sorry, Judge?
Hold on. Just a second. Pardon me.
Hold up. My internet's slow. This judge don't know what he's talking about, man. I mean, what he's getting away with is just this has to be illegal. This has to be unlawful. Hello, Ron, and everybody. Hope everything is well. From Australia, what is going on? Visaleu, Tiki Latu. Thank you so much. Got Australians in here. This is proof that America's corruption in our judicial system is literally on display. We have Australians here in the chat watching all of this nonsense go on. It's absolutely ridiculous.
Those being broadcast to other people, and as to how that information was disclosed, that's a real problem. That's why it's of such an issue for the court at this point in time.
Judge, and Mr. Steele has a right to make a motion like this. If there were ex parte,
he does. I'm not saying anything, but but he's kind of put himself in the particular position he's in.
This is an abuse of
Judge,
power.
I don't agree. I believe that
I'm going to disagree with you, okay?
I believe that the court has put him in that position.
No.
He cannot be held in the law states, McClarity, which I cited to you earlier.
And it's true that direct summary contempt, which arises in the presence of the court, intends to scandalize it and or hinder or obstruct the orderly process of the administration of justice. The preservation of order and decorum of the court is exempt from due process requirements of notice and hearing. That's even Moody, goes back to 1974. So I believe that Mr. Steele's, he can file whatever motions, but his particular actions in this case, I just want to know who told him this. That's all. I'm not asking him to release or otherwise tell any conversations, but I just want him to tell me that.
And Judge, so that's what you want, but that does not conflate to a contempt. Your desire for him to answer your question does not mean that you have the power to hold him in contempt. So
you can come into court, Mr. Merton, and not answer a question of the court and not be held in contempt?
If it's a question that the court is not permitted to ask, yes.
Okay, well, this is a question the court's permitted to ask.
And it's our position, if we had a hearing, we could explain to the court why he is not required. First of all, the court accused him of eavesdropping. That is a crime. He has a Fifth Amendment privilege against answering those questions. Rule 1.6 protects all confidential information that is gained not from your client, but in representation of your client. He has the ability to protect that information. But we don't even need to get there because he can't be held in contempt, and you can't threaten him with contempt for presenting a motion in good faith. He presented a motion in good faith that he believed there were ex parte communications. You are a witness to that because it's my understanding that you were part of those ex parte communications. They can't be ex parte if you weren't part of them, by nature.
Boom. Merchant told Glanville, look, you got a duty to inform the defense counsels that there were ex parte communications being made, and that the main crux of Steele's argument was that he should not have had to learn about this ex parte communication from wherever the heck he learned about it. Judge, don't worry about who my source is. This should have been information provided without having been discovered. Because in other words, if it weren't for Brian's source, for Mr. Steele, if it weren't for his source that let him know about this ex parte communication, the judge wasn't going to tell him. They didn't tell him. You see, so according to the Georgia Code of Judicial Conduct, judges shall not initiate, permit, or consider ex parte communications or consider other communications made to them outside the presence of the parties or their lawyers concerning a pending proceeding or an impending matter, subject to the following exceptions. So it also states that when a meeting does not deal with substantive matters, the judge must promptly notify all parties of the substance of the ex parte communication and gives the parties an opportunity to respond. The judge did not do that. Ashleigh Merchant is calling out what he is doing, and he is basically trying to ignore what Ashleigh Merchant is presenting to the court. And this, to me, is a clear abuse of power. What do you guys think? If you guys haven't already, please hit the like button for the video. I totally appreciate you guys. Subscribe, share this video with a friend and like-minded people. And I'm going to see you guys on the next one. Have a good night.